All right, everybody. My name is attorney Manny. I'm following up on Adam's presentation. So what we're going to be doing here in session 2 is building a strong defense foundation. This is going to look a little bit different depending on where you're practicing. Obviously, it won't be defense if you're a prosecutor watching this, but certainly there'll be a lot of applicable overlap to some of the information that's being collected and how you can use it in prosecution. And then obviously defense. What's important here is getting to know your client, getting to know some of the legal issues you're going to be having, preserving evidence that may die without preserving it. And then also the DMV aspect at the very end. So within 10 days of a DUI arrest, you have a lot to do with the DMV, and it's important you make the appropriate decision. That's not just going to help your client in the next 30 days, but what's going to help them in the next 3, 4, 5, 10 years, perhaps, because there are some negative consequences that come with the DMV. But first, building a strong defense foundation. What we're going to go through in these topics in this session, right, is information gathering, providing education, setting expectations, and discussing the 10-day rule. It's important that when we're talking about these things, this is not kind of roll your eyes, boring stuff. A lot of the relationships you make with your clients go well beyond the result in court, and it starts here, meaning that they want to have trust in you. And if you have a great result in court, but the entire time during the case, your client thinks they're unheard or have been neglected or don't have their team overturning every stone, or they've met with 2 or 3 different lawyers. Or if you're a public defender and you're meeting your client and they talk to a private lawyer, these other lawyers, if they talk with them and they ask questions that you didn't, maybe they're not hyper relevant questions, but if they have a little bit of relevancy, you should have been asking them, right? So there's a lot of data, information, and collection that has to go into a case to really paint a file to become a human, right? You want to humanize your file. So we want to make sure that when we're talking with people as lawyers, we hope, a staff or a online form or a one-pager or something where your potential clients or actual clients can fill out the information prior to you actually meeting them. So you're going to be able to have some background going into that meeting so you can set the trajectory. But regardless of that, you should have in your back pocket a list of questions that need to be asked for every single client facing a DUI charge. And the questions you're going to ask are so very different than someone facing a possession of drug paraphernalia or a aggravated battery offense. A lot of times you need to know the lay of your land as well when you're going into these questions, because all of them have a reason. And it's the reason why you ask the question and need the data. And it's important that you let the client know the why behind some of these questions, because they may get distrusting of you when you're asking some things, such as, is this your first offense? Do you have any mental health or substance abuse issues? Have you ever had any alcohol-related offenses in another state? So there's a lot of things that really are important to explain to a client, that you're not just at the doctor's office asking, that checklist that the nurse will ask you prior to a meeting with the doctor. This is similar to that, but I want people to know the why, and the client should know the why so they feel comfortable with you. And one of the things that I always say when we're double checking with a client is not, have you ever been arrested before? Okay, some of the questions, if you say, have you been arrested? Clients say, no. But as we may know, or maybe you come to find out, that a traffic criminal citation, such as a driving with suspended license or no valid license, often doesn't result in an arrest. So they say, no, I've never been arrested before, and you move on. And unless you double check whether they've had prior offenses, you could be gearing someone up for a diversion program or a different kind of result in the case when they're actually in trouble based upon having 2 or 3 prior DWLSs. You could be looking at a hard HTO, right, if there's 3 offenses within 5 years. So all in all, information gathering is extremely important. It can be very, very detail oriented. You should have a process in play with written out questions that are standardized and systematized as to when you get that information, what you do with it, right? So not good enough to just have the standardization of the questions, but also systemize how you're using that information to make your case go forward. And really talk with them about anything that you're able to gather prior to meeting with them. If you go on the clerk of court, you can pull the citations, you can pull the probable cause affidavit, you can look to see if they're on pretrial release. You know how helpful you can be to someone by explaining what pretrial release is? Because if you've gone in for a magistrate judge there, you're getting through the craziest night of your life, having been arrested, you're in that cattle call of magistrate first appearance court. They say some stuff on a screen, they shuffle you on out, and you get some paperwork when you leave. You're supposed to bring your whole life together and worry about how to report 2 times weekly and call within 24 to 48 hours of your release. And then when you call, no one's answering. What if you're arrested on a holiday? You don't want to be in violation. There's a warrant going to come out for your arrest. So being there, that guiding light of how to get through that first 48 hours after arrest is extremely important as well. you want to let them know, first things first, that everything you talk about is governed by attorney-client privilege when you're talking to either a potential new client or your actual client. If you're a public defender meeting this client at arraignment, or if you have the luxury of calling them prior to arraignment. I know that's really hard for any public defenders listening to this, may roll their eyes. I was a PD back in the day in Broward County, so I know the pain of those arraignment dates or PD sign-up dates where everyone's really filling out the public defender applications. But and you're meeting your client for the first time, trying to get all of this information. On the private side, you're actually able to really have a sit-down conversation with these clients and gather a bunch of information, which also helps your defense going forward. So when people ask, oh, do I need a private lawyer or a public defender for this? It's tough to say a PD, because when you're a public defender, you're not able to gather all this information until maybe 2 or 3 court dates down the line because you're so pushed for time. So hopefully the CLE will help some of the public defenders understand the questions they need to ask at that arraignment date or that public defender application date, and have that little checklist perhaps of what you really are looking for on a DUI. So one of the things you want to do as well is make sure you have a check here for conflict. So a conflict check to see whether there's anything involved with this potential client that would be a conflict and require you to decline the case or not even get into sensitive information with the client. So it's always important to have that in play on your CRM, or obviously at the public defender's office, everyone has a different form of conflict check that they run. So information gathering, right? So if we're looking at a golf swing, are we doing a draw? Are we having a slice? Are we hitting it straight? We want to make sure that we're setting the trajectory of this defense. So if your club is angled a little bit in when it should be flat and flush, you're going to end up having a draw or a slice. And so it's important. I also like to use the analogy of a rocket ship. It's just where if we set the trajectory of that rocket ship off 2 or 3 degrees and we're trying to land on Mars, we can land on Saturn, because we are trying to project out in the criminal case on a DUI, maybe 3, 6, 12 months from now, what this looks like subsequent to the arrest. I just choose to use the golf swing because it helps me realize how poor of a golfer I am. And so when we do this, we want to know injuries, physical conditions. So those 2 things, speech impediments, language barriers, learning disabilities, where were they coming from? Where were they going to? Defense witnesses, and much more that you won't get in the state's discovery. So just bringing it back to the original session, the first one we did with Adam, he had a lot of little points on the motion to suppress and legal issues when field sobriety exercises come into play about injuries and physical conditions, and officers maybe kind of glancing over that or not getting the full totality of the circumstances. If someone says, hey, do you have anything that will affect your ability to perform these field sobriety exercises? As a defendant, as a driver, how do you even know what's coming next? They don't explain to you everything they're going to ask. So you're answering that question without knowing what the things they're asking you to do are. So you don't know if you're going to be asked to stand on one leg. You don't know if you're going to be asked to do spins. You don't know if you're going to need your wrist or shoulders or neck muscles or back muscles or lower back muscles by standing on one leg. So these are all things that when you're talking with your clients as the defense lawyers, you want to see, are there any injuries they have documented in the past specifically where you can get medical records that they've actually had vertigo recently or inner ear problems, or they've had herniated disc or plates in their foot, knee issues, scoliosis, arthritis, you name it. It's all relevant. It's extremely relevant because you can use that to explain some of the performance on the exercises. And maybe you should have been asked to do the alternate roadside exercises where you're seated. A lot of times they do those on boats, right? Because your equilibrium on boats is really hard to walk in a straight line, stand on a straight or on one leg when you've been on the water all day. And that's the same holds true for people that can't really stand and balance or have some issues. And so understand right now that when we're going through these things, learning disabilities matter as well. And so why do I say that? Because these are divided attention tasks is what the officers are going to say the field sobriety exercises are. And they're going to be told one time that there's about 6 or 7 things they have to do under pressure on the side of a road with one foot in front of the other, arms by their side. It's nerve-wracking. And if someone does have a learning disability and the officer doesn't really understand how to teach someone with a learning disability that they have that's documented, it can really lend credence to why they didn't, quote unquote, follow instructions, because they're going to struggle to pick things up on first go round. Where they're coming from, where are they going to? That's important for you to know. Now, the officers may ask that, but let's take it back. Were they at work during the day? Can we get work logs to show that they were staring at a screen, which is why their eyes might be bloodshot or watery? Were they wearing contacts that they didn't change out and they left straight from work to go to a happy hour, perhaps? Who were they with during that time? And who were they with at the happy hour? And were these people that would have a better understanding of what, let's just call him Bob. Bob got arrested for DUI after leaving a work happy hour. Are Bob's defense witnesses going to be his coworkers and colleagues that know him, that have seen him have 1 or 2 beverages, that know he walks with a little bit of a limp and is a little aloof in the brain and needs to be explained things 2 or 3 times sometimes, but he's really good worker. He just sometimes needs to hear it 2 or 3 times to really get it. Are those individuals going to be able to stand up and say, I can vouch for, I was with Bob that night. I did not see his normal faculties impaired. I see him on a daily basis, et cetera, et cetera. And not that you're gathering this information to 100% call these witnesses at trial or a motion to suppress, but you need to have this ammo in your gun, in your artillery. I can't say that, artillery, to then be able to use in court to defend the case for the clients. And you don't know the answers to these questions unless you ask. That will not be listed in the witness and exhibit list of the state attorney. So it's important that you really gather that information as you're moving forward in this case, so you can set that trajectory of the case, and your client's going to know you care and you're listening, because their whole story of that day was not collected by the officers, most likely wasn't collected by the officers. And some of those questions, okay, that the setting the trajectory questions that I was just talking about, some of those you can actually see on the police's probable cause affidavit. Ones in Palm Beach County have a very good list at the end of it, as to a million questions that could be asked if the clients don't invoke their right to remain silent after they provide a breath sample or refuse it. They have a giant long list of questions that it almost feels like a real strong interrogation of your client. And those questions that they're asking are some that the defense counsel really wants to know the answers to, and we can use it for defense purposes. So it's interesting, the overlap there that can be used to defend cases. What else do we need to know? What is their profession? So obviously, as a criminal defense lawyer, it's very unlikely that you are a profession lawyer, a stockbroker lawyer or a school board lawyer, but there is overlap there where you may have to write some letters or work with another lawyer on protecting your client's license. What do they do for a living? Do they have a CDL? So a commercial driver's license, we can do a whole 8-hour course on just CDLs and the effects that it has, affects a DUI arrest and conviction can have on your CDL. And that's crazy for some of these clients who make a very good living driving CDL, and all of it can be gone like that. Where do they see themselves in 5, 10, 20 years? Again, the result for a case that someone just wants to be a bartender or maybe a physical trainer or something like that is much different than someone who says, yeah, I want to work in education, or I want to be a school teacher. I want to work in healthcare. These DUIs on your record can really hinder your career. So you want to know where the client's looking to go, not just now, but in their future. Prior arrest, I talked about earlier about, is there a difference between, we need to make sure, we pick up the difference between an arrest and have you had a criminal citation in the past, and make sure they're together. Have you ever had any incidents with law enforcement is a good way to start that question. Very open-ended. You may have to kind of narrow down the answer, but it's important that you ask that open-ended question so that the client can share with you what's gone on in their life. As Adam even mentioned before in session 1 here, there are some out-of-state DUIs that aren't DUIs, quote unquote, in other states, but Florida does look at them as a DUI. So there's a giant sheet that you can find online of sentences for repeat offenders and DUIs in Florida, the statutory minimum mandatories. And you can look at those and see if it's a second DUI within 5 years, second without 5 years, third DUI, et cetera, et cetera. And you can look at those charts, and that second DUI, any second DUI is a big deal with the DMV and criminal court proceedings for sure. But a second DUI within 5 years does have that minimum jail sentence of 10 days. Now, there are some workarounds to that through the statute with some inpatient treatment and things. However, it's important that you tell the clients this from the beginning so they understand how serious this is. Because if they had a prior DUI and they just, quote unquote, just got some probation, you hear that all the time as a lawyer, right? This time is not going to be as easy. It's really not. There's a lot more on the line. There's a lot more strength that the, I guess, negotiating power, if you will, that the state attorney is able to start with, just because that statute has already kind of got you in a hot water of that minimum mandatory jail sentence. And it's a very tough pill to swallow for some people. So definitely look into, if this is their second DUI arrest or third or fourth, what that means, because you should set that trajectory for them, that expectation for them in the beginning as to how this is different than their first DUI. See how open the client is to a reckless driving or careless driving or diversion programs, because you have a very short period to make that decision with the client as to what they want to do. Most DUI diversion programs require you within 45 days of arraignment to be enrolled. And there's a lot of steps that have to go into that DUI diversion program. Some counties require prerequisites to be enrolled in prior to getting into that diversion program. Some counties don't offer it. But it's important to know what your client is comfortable with moving forward, so you can then posture yourself in a way that's going to help them get the result they want, not chop it off the table. Because if you do request some discovery in the case, some diversion programs will automatically disqualify you. And then you're going to have to beg, borrow, and talk to a supervisor and fall on a sword if you did mess up. And that's not a good look for anybody. We want to know if they're a citizen. Obviously, there's an ever-changing climate in our country regarding ICE and deportation and their presence at the courthouse. So it's always good to know if they have an immigration lawyer so you can talk with them, because there are certain resolutions like a reckless driving or careless driving that are so much better for people in immigration court than that DUI. Again, not an immigration lawyer, but only I've learned along the way, because there's a lot of overlap, to always consult with the immigration lawyer prior to accepting any resolution on behalf of a non-citizen. Providing education. So this is more of a personal thing that I believe as a lawyer you need to do for your clients. You need to make sure that you understand the lay of the land. You need to be honest with them. You do not spew BS or blow smoke at them up there, you know what's, because that's not going to get you anywhere in life if you're posturing to be something you're not, especially with a client whose life is in your hands, their profession is in their hands, their family's stress, it's all their profession, like I said, is in your hands. So you have to make sure that when you're talking with a client, you are informed. What is the judge that they're before like to do on these type of cases? Are they, I'm going to set this for trial in 60 days and file a continuance if you need to file a written motion for continuance? Do they allow for depositions? Do you need a written motion for depositions? In the order, do you have to then state in the order what officers you want to depose? Do they limit the depositions to only 30 minutes or to an hour? Did they say you can have what's called a hallway depo of the officer? Do they require your client's presence? Do they allow a waiver of appearance? Are they on Zoom? I can go on, but if you don't know the answers to these questions when a client's coming in to meet with you, or you meeting with a client for the first time and you're going to try to tell them how this case can go, you're already a step behind. You really want to know and educate them on what this process is going to look like. You want to feel like you're authority. You want to be the authority at that moment of what's going to happen in this case as best as you can predict. There are no guarantees, but if you've been through this before, or you've watched this CLE, you can say, I've studied up on this. Let me tell you how this typically goes in this courtroom, or how this case typically happens. Because again, this is not the time to be selling, or blowing smoke. It's a very serious allegation, very serious case, like Adam was saying before, and I'm sure my colleagues will say later today. This can really mess up your future because the statute is so heavy, DUI. And so I'm just putting it out there that you guys definitely should be studying the statute and learning about your local jurisdictions or the courtrooms that you're going to be heading into when you're defending these cases. And don't forget about the DMV. There's a lot to learn about the DMV. And third, from one of my favorite movies. So this is 500 Days of Summer. It's an indie movie. It'll let you know a lot about me. It's got a great soundtrack. But on the left side, this guy is always throughout the entire movie having this crush on this girl named Summer. And it's kind of coming to this climactic scene at the end of the movie where he's going to this dinner party that she invites him to. And he thinks she's inviting him as a date. And they're going to have this romantic dinner together. And they're going to go off into the sunset as a couple and, have a great, great night together. That's all in his head. When he arrives on scene, she puts him directly in the friend zone. She's with her friend. She's not paying much attention to him. He goes in for like a hug and a kiss, and she kind of gives an awkward handshake. It's a great movie. And this scene, if you know what I'm talking about, you're probably nodding your head and smiling like, yeah, that was a rough scene to watch, because the guy just gets completely let down because he had all of these romantic ideas in his head. That's your clients. Okay, that guy is your clients heading into court. They think this is some movie, especially if you're at the public defender's office. You'll walk in on an arraignment date, or you're signing up with a client, and they're going to want a speedy trial. They're going to ask, if the officer's not here, doesn't this case get thrown out at arraignment, right? They're going to say, can't we pull his internal affairs file and question him, and can I sue him, right, while this is going on? There's going to be a lot of expectations that have to be managed, and if you can do that from the beginning and not have to play damage control down the road, that goes a very long way. Clients, even professionals who have never been involved in the criminal court, I'm talking about brokers, I'm talking about real estate agents, doctors, they don't know what an arraignment is. They don't know what a calendar call is. They don't know what a status is. They think they are going to trial with a jury on that day. So you really need to have that timeline of what you can expect in this case, and let them know, hey, it's going to be a quick little, maybe 2-minute hearing with the judge and the prosecutor. I'm going to get the offer. We're going to enter a plea of not guilty. We're going to get some depositions, or we're going to set this out a little bit so we can work with the state, maybe get you a diversion. And let them know you're not going to be, Tom Cruise and A Few Good Men screaming up there, you can't handle the truth, right? Who ordered the code red? And having this whole cross-examination of someone on a jury stand and delivering, or excuse me, on a witness stand and delivering an argument to the jury. That's not going to happen for at least 10 months per se, whatever your local county does for those type of cases. How long, whether a DUI is 3 months, 6 months, 9 months, 10 months, whatever. But I'm telling you guys this because you guys might not think that this is legitimate. I'm telling you, it's legitimate. They think it's a movie from Suits waiting to happen, from the show Suits waiting to happen. Do not feel the need to answer what are the percentages that you're going to beat my case. Hey, that's a troublesome question to answer. You should never do that. Obviously, the bar has rules against guarantees and things like that unless they've been verified. When do I have to go to court? When will we talk again? How long until we get discovery? These are all things that you can get ahead of and provide the answers to these questions without the client actually asking them. And that feels so much better when you're taking, the reins here and guiding this thing forward. Clients feel taken care of. They just want to be in the know of what's happening. Like I said earlier, the uncertainty that happens, this is a peek behind the curtain, right? The uncertainty that goes through a client's head from the arrest to the end of the case, let's say it takes 6 months, is probably way worse than doing the probation on the actual sentence if you were to get probation as a sentence. During the pendency of this case, it's very stressful for them. They're seeing that I could get 270 days in jail for this. Are you kidding? Right? I haven't talked to my lawyer. I've just been Googling things. It says, I could go to prison, even though you can if it's your first DUI, if there's no serious bodily injury or anything like that. But that's what, especially ChatGPT is not perfect with DUI, let me tell you. So if someone's using ChatGPT to educate themselves on DUI, they could really be going down a wormhole. So let's make sure we grab our clients out of that wormhole, set their expectations, answer some of the questions that they may have without them asking. And then also let them know this is not a movie where I'm going to go in there and start, off the cuff, lobbing insults at the prosecutor and telling the judge that they don't know what they're talking about and pleading with the jury to find him not guilty, our client not guilty. Obviously, that's not happening at an arraignment tape. The 10-day roll with the DMV. Okay, so this is important. I want everyone to take some time to listen to what I have to say. There's a lot more that you can look into this. Again, if we were talking about earlier about lectures that can take 8 hours or so, the DMV's process can take 25 hours to explain. But let me try to dumb it down so at least we get the basics here. Within 10 days of being arrested for a DUI, you have to make a decision with the DMV what you want to do with your license. First off, if you got arrested and you blew into the breathalyzer, okay, the DMV will then hold a formal review to make a decision whether that breath was valid, whether the machine had been properly calibrated, and whether there's two samples within an agreement of each other. If the officer made a valid arrest, if the stop was valid. So all type of legal issues the DMV can look at as to whether to make a decision, whether to uphold the suspension of your license or not. And if you blew into the breathalyzer versus refused the breathalyzer, you're facing and this is your first DUI, you're facing a 6-month driver's license suspension. And if you lose this formal review, if you challenge the suspension with the DMV and they figure out that, hey, we do think the press were validly collected, we do think the arrest was proper, we think the stop was proper, not only do you have that 6-month driver's license suspension, but you have a 30-day within their hard suspension where you can't even apply for a hardship. So you may say, why would I want to do this formal review if it's going to risk me having a 30-day hard suspension? Because if you waive the formal review, okay, and you elect to not challenge this with the DMV, you actually, in most cases, can apply for the DMV to give you a hardship license. So you can drive from school, work, religion, childcare, groceries, medical appointments, those type of things. You can do that with a temporary license called the hardship license that can last during your 6-month suspension if you provided a breath sample, 1 year long suspension if you refuse the breath sample. And so everyone really wants to get this hardship license. But what they don't tell you is that you've got to actually enroll in DUI school. Okay, you have to complete it within a certain time frame. And then you have to apply for the hardship license with the DMV. And there could be a 2-week waiting period or more, depending on how backed up the DMV is, to get your actual hardship license. So even if you say, I don't want to challenge this with the DMV, let me get my hardship license as soon as possible, you can be waiting for a pretty long time without going on the road. So a lot of the times our clients go, all right, let's just challenge this thing. What are the odds? Well, the odds to win these are not high. Okay, right? Like we say, don't feel pressured to answer that question, but certainly the odds are not high in the state of Florida. The person who presides over your formal review hearing to make that determination as to whether, if you provided a breath sample, was it valid? If you refused a breath sample, did you refuse it after being read Florida implied consent? And then in between with both of those instances, was there a valid arrest? Was there a valid stop? Is an employee of the DMV. They are not a judge. They're not a lawyer in most cases. They're not a magistrate. And so that employee is faced with this administrative hearing, making the determination as to whether these officers did their job or not. And the burden of proof is very low. It's not beyond a reasonable doubt. It's preponderance of the evidence, whether they did their... Most times you win these formal reviews as a defense lawyer when the officers just fail to show after they've been subpoenaed to be there. The negative consequences, I was kind of talking about this before, for a refusal to submit a breath test versus providing a breath test are more severe. So if you refuse the breath sample, your license is going to be suspended a year if this is your first refusal. If you gave a breath sample, it's going to be suspended 6 months. If you refuse the breath sample and you lose the formal review, not only is your license suspended a year, but this time you get a 90-day hard suspension. That's a long time, 3 months of no driving whatsoever. While we go back to the breath sample, where we provide a valid breath sample, no matter how high it is, the license is suspended for 6 months, and the hard suspension is only 30 days. Okay, no driving whatsoever for 30 days. So 30 days before you can get your hardship on a breath, on a refusal, 90 days before you can get a hardship. So a lot of the times clients ask, why would I do this formal review? Well, if the odds are so low that we're going to win, well, if the officers don't show up, we're going to win, which is fantastic. So there's no suspension on your license. There's no DUI on your DMV record. However, you can use the testimony from this hearing to then defend your criminal case, because they make a recording of all these hearings, and you're able to use this for motion to suppress, for impeachment purposes, whatever it may be, especially in your jurisdiction if they don't allow for depositions. A lot of the times losing this battle with the DMV to win the war in the criminal case is a really good strategy, so long as your client can stomach not driving for the allotted amount of times depending on their situation. Now, here's another thing that I tell people all the time, okay? Where if a lawyer says, hey, should I refuse the breath sample? If a friend or a client asks the lawyer, hey, should I refuse the breath sample? Or what should I do if I'm pulled over? Should I refuse the breath sample? And if the lawyer answers yes every time, you could be committing malpractice and furthering a crime. Why? Because if you've refused a breath sample prior in the state of Florida, and then you refused it a subsequent time, so a second or more time, that's actually a misdemeanor, okay? You're also not going to be eligible for a hardship license. There's a longer suspension, it could be 18 months on that. So don't always just blatantly say, yeah, you should always refuse a breath sample, because that can get you into hot water. Now, most times, is it best not to provide a breath sample? Well, it depends, but you don't want to give the state evidence to then use against you. It's the state's burden to prove the case, so it makes sense logically that we don't want to give them any evidence that could hurt us. However, again, just remember that if you've refused the breath sample before in the state of Florida, if your client has, and then a second time you refuse it, that's a crime. Okay, and some jurisdictions take that very seriously. Sometimes it's tougher to get a non-jail offer on that than it is for a second DUI, believe it or not. So I just want to put that out there so that you guys know and carry that with you along the way, because some people make a big mistake saying, yeah, you should always refuse their breath sample. And I cringe every time I hear that. Next. So the 10-day rule, like we talked about, this is that 10-day rule. The statute's down there on the bottom. So if you want to look at it, you can go ahead and check that out. I got Muggsy Bogues and Michael Jordan throwing up some 10s. And then the next slide, I believe, is just a little bit further how I was breaking that down. So in case you're a visual learner like me, this will help you. So maybe take a screenshot of this. You could also just Google some of these things, and you'll see some good breakdowns on the DMV's website itself for some of this, where it talks about that 12-month suspension on a refusal, 6-month suspension on a breath test, and then the hard suspension thereafter. I do see that we've actually have some questions in here, and I know I have about 7 more minutes. So let me, hold on. Well, let me get to the connect slide. So keep in touch, go ahead and hit the QR code. You can always kind of shoot me anything you need. The firm is fantastic. We'll be able to help you out. And let me see. One of the questions here is, when building your case theory, how do you balance juror skepticism of DUI defenses with the need to humanize your client and discredit the state's evidence? So that's a big question. It's pretty loaded. The important thing, the juror skepticism, that all starts in voir dire. You're going to hear about that later as to how that actually plays out in getting a fair and impartial jury, and how it's a voir dire in a DUI case is so different than if you were doing an aggravated battery one or a murder charge or a violent offense. So I've always found that the violent offense violent and white collar cases offenses are so much easier to pick a jury than a DUI sometimes, because there's a bit of underlying prejudice against DUI that people have, and they have a lot of friends or family members that have maybe been affected by someone who's been in an accident, or they've been hit and they could have sworn the other person was drunk, and it takes pulling teeth to get that out of them. But I'll leave that level of explanation to the session about voir dire and trial strategy and trial prep. But the humanization of your client, it's always tough to do that because you want to get information and you want the jury to hear how great your client is and everything about them. But a lot of that won't be relevant. And in fact, the state can object, and a judge sustain an objection if you're trying to throw some lobs in there about your client's profession and things of that nature to make it seem like they have a lot to lose. You can try to get it in through some examination of the officer, or if the body cam video has it. But it's really important to understand that a lot of that might be motion eliminate out. There is a very strong tendency to make sure that the evidence and facts being presented to the jury are relevant and don't sway one person to think that your client's innocent or have tons of sympathy for them. You want to draw as much sympathy as you can for the defense lawyer, obviously, but it goes both ways, right? The state, a lot of times, you're trying to keep your client's previous criminal history out. You want to get as much bad stuff out of from your client as possible. And when you want to bring in the really, really good stuff, a good state attorney is going to know, hey, we need to have a hearing. We need to have a little ruling on this, judge, how these things should not be brought up. They're not relevant. So it goes both ways. Another question. Okay, lots of good questions. Let's see. Most underutilized suppression motion arguments. Okay. So I got a question here asking what motions to suppress have you come across essentially that are underutilized that can be used a lot more? I've got a really good legal theory that the totality of the circumstances, if someone is forced to do the quote unquote voluntary field sobriety exercises, that prior to they should have been read Miranda rights, that they were never voluntary to begin with, that person felt obligated or compelled to comply with all police requests. And so I've actually filed some motions to suppress that. I've won some, lost some, got some breakdowns on them, where a client, let's say, is getting pulled over and officers coming at gunpoint next to her car because she failed to pull over for a few, like 2 or 3 blocks. And so the officer did like a felony stop, hopped out on her with his gun drawn and asked her out of the car. He didn't ask her, commanded her out of the car. And then right when he put his gun away, realized she was a sweet old lady, started kind of going through things in a nice, calm tone, didn't apologize, didn't ask if she's okay, just went about his business as, okay, she's not a danger to me. Let's keep going. And you could tell my client was frazzled beyond belief, could not keep her wits about her. So there's a lot that happens in those type of cases where you need to look at the totality of the circumstances and formulate any kind of suppression arguments that you can have regarding police forcefully commanding people and compelling people to do things versus requesting them. And there's some interesting case law on both sides. And that one's not one you see. Typically, you'll see the motion to suppress for failure to maintain a single lane so long as no other traffic is affected. Some officers write failure to obey a traffic control device instead of failure to maintain a single lane. And those are a little harder for defense, in my opinion, to beat because the failure to maintain a single lane, there's so much good case law out there that if no other traffic is affected, you can have a really good argument with the state. Improper starts, those are really fun ones. If an officer says like the car rapidly accelerated off of the line, those are fun ones to go through. Dash cameras. Okay, I didn't talk about this before, but collecting dash camera from your client, if they have it, especially a Tesla owner, is imperative. We have 2 times, same client got a case dismissed through a motion to suppress. Both times actually went to hearing, where our client had a dash camera that recorded everything that happened. The officer had no idea that it happened. It wasn't the same officer. It was actually 2 different counties. And we were able to use the dash camera to discredit them, impeach them, and ultimately win motions to suppress based upon the officer saying ABC happened, and the dash camera clearly shows XYZ does. And those officers did not have dash cameras, they only had body cameras. And both of them were for challenges of the stop. One was failure to maintain a single lane, the other was improper start. So it was a really big win for our client both times. But without that dash camera, there's no way I don't want to say no way. The odds of winning that motion were in single digits, I would say. And so it's really important that you try to collect as much dash camera as possible. Another question. Oh, Hunter hearings. So this is a really good one. Someone asked about Hunter hearings. So if your client, you may run into this. So this is somewhat basics DUI, but this goes a little bit detailed more. So if you run into a client who gets into an accident, okay, and they call you and they say, "Hey, I drank a little too much. I was at the hospital. They took my blood." The officer asked. I said, "Yeah, you can take my blood." Or they took it for medical purposes, but the officer said he's going to get it anyway. I wasn't arrested, but he said to be on the lookout for something in the mail. What's going on here? So a Hunter hearing can happen where the state says, and they ask the judge for a release of a client's medical records to see what the blood results were, if it was medical blood. And if there was an ongoing police investigation, which the state makes an argument that it's continuously ongoing, right? Just because the night ended and the officer had to go home and end his investigation on that night or involvement that night doesn't mean the total investigation's over. And so I understand that argument from the state. I think it's a strong one. I try to discredit a bunch. Odds are the judge is going to open up those records, those medical records, for the state attorney to review for prosecution purposes. And that happens prior to the case being filed against your client most times. And so you'll get a case number in a court hearing sometimes just for the Hunter hearing itself. What I like to do, and I think is appropriate, and there are certain judges, at least in the jurisdictions I practice, that like to do it as well, is that they review the medical records in camera, okay, so within their chambers, to balance the HIPAA violations, or not violations, HIPAA type of privacies that clients want to have for their medical records, where the judge will black out things that they don't believe to be relevant and leave those things on there that the state attorney is looking for, such as blood alcohol content or any kind of drugs that was in the client's system and other things that the medical records may allow for the state attorney to use against the client in prosecution. So, a lot of times judges will grant the Hunter hearing, the state's request to get the records. You do have to object in writing from the state, from your defense side, to try to protect against this, or else they're going to get granted. But again, the judges like to do that in camera to review the records, and I think it's a really great practice. Some of them don't, but I think it's a great practice for the judges to do that, to just be there for the defendant and protect him or her against some of their information becoming public or with this into the state's purview that they have no real reason to actually have. Okay. So another one is, how do you structure your initial client interview to elicit some of the facts? Oops, sorry, it went down. Necessary for constructing a solid foundational defense, especially when the client may be underinformed or misremember key details. So two different things. One, as we heard in session one of the presentation, DUI is really great to start in a chronological order of how that day started all the way up until how it ended. Some crimes, right, you want to work from the back, from the end result backwards to try to figure it out. So you always want to tell the client that, hey, look, it's not a judgment zone. I'm going to hand the microphone over to you and just lay it on me. I'm going to be typing some notes, but I want to hear how your day went. Who were you with? What did you eat? What did you consume? Just talk to me about what happened that day. And open it up for them to be vulnerable, and then telling them, hey, I may jump in, cut you off a little bit to ask you some follow-up questions, because that's my job. Please don't think I'm being rude. And telling them that they're like writing into their diary, and don't be afraid to overshare with me, because there's a lot that we can use here to help defend your case later. That's how I would really go about that interview without having things actually listed out. I do have a list. If you want to reach out for me privately, you certainly can email me. We have our own tried and true method on that client intake, if you will, where we have a whole list of questions that we have to make sure are filled out for all of our clients, so that we're overturning every stone to try to beat their case. So if you're interested in that, whoever asked that question, you can go ahead and shoot me an email, and I'll be happy to give it to you. And then if they're misremembering key details. So that's important, right? Clients may call you and they're misremembering, or frankly speaking, they were extremely intoxicated and they don't remember. And when you are having those conversations, don't judge, right? If it's a misdemeanor, luckily no one got injured, or if someone got injured, just be there for them. Everyone makes mistakes, some mistakes bigger than others. Let's not let this moment define the rest of our lives, but let's see what we can do from here. And just have that client try to remember as much as they can, and then fill in any blanks that are there. Let them know that when the state gets their discovery, I'm going to do my best, okay, to fill in these blanks for you and have a call. We have at our firm something called discovery calls, where anytime the state attorney gives us the discovery, we review it, we make some detailed notes, we send that stuff to our client to review, and then we set up a call where we're actually going to review the body-worn camera together, we'll review the police reports, we'll do a screen share if they don't want to come in person, and break down the state's discovery, some of the legal loopholes we may see there, right? And I say legal loopholes, I just say really good motions to suppress or issues with the case. And in so doing, with the advent of body-worn camera being everywhere and dash camera being on a pretty good amount of police cars, compared to obviously when I first started practicing, Uh, that fills in a lot of blanks. Now, where they were that night, things like that, maybe look at their credit cards, trying to look at their text messages, talk with friends that they were with, and that's all relevant. And that was a really good question, because if the client can't give you the details, how do you find them? Look, could you hire a private investigator? Sure. But on a first time DUI, there's other ways that you can get that without spending the client's money. Okay. Next thing we could talk about is some talking about different jurisdictions and maybe the climate changing. I'll talk a little bit about diversion programs. So what's really good about a diversion program, I don't think we have any of the slides in here about diversion programs. The difference between a reckless driving, careless driving, and a DUI. So in the state of Florida, if you get convicted of a DUI, you have to carry FR44 insurance for 3 years. That's really expensive. We're talking like $15,000, $20,000 over those 3 years that you have to be able to operate a vehicle on the roadways of the state of Florida. And it's like a rain cloud that waits to rain over your head. So you can't say, I'll just wait 3 years. When 3 years passes, then I'll get my driver's license. No, it's waiting. It's going to rain for 3 years. It's going to burn a hole in your pocket. So a lot of times with the DUI, what lawyers don't tell you, or the law doesn't tell you, or in court maybe isn't explained to you, is that there are very serious required insurance premiums that you have to pay in order to operate a vehicle in the motor on a roadway in Florida. In addition to that, okay, when you get a reckless driving, if you get a withhold of adjudication on it, you don't have to have SR22 or FR44. So those are two different types of insurance, special insurances you have to carry as a driver. But you don't have to have either of those if you get a withhold of adjudication on a reckless driving. And withhold of adjudication, if you're watching this in Florida, I hope you understand what that is. If you don't, it means that you can technically say in the state of Florida that you weren't convicted of this crime. The judge withheld adjudication, or the state offered a withhold of adjudication. And that's fantastic. You can end up sealing your record in a lot of instances. Now, here's the problem. DUI is a mandatory adjudication crime in the state of Florida under the statute. You got to really know this statute. Okay? The DUI statute's imperative if you really want to be a good to great DUI lawyer. And so understanding that it's a mandatory adjudication, and the client, if you resolve the case, you go, yeah, you can seal your record after this. That's wrong. You cannot. And once you've been adjudicated of a crime, you cannot seal or expunge any other crime on your record. So knowing that a DUI carries that mandatory adjudication, all the hard work you have to do to try to beat the case is not just to get out of a jail sentence, is not just to get from DUI to reckless driving so it feels better for a client, is not just to maybe have lesser driver's license suspension or lesser probation, but also to try to save their reputation for the future. Also, when clients get arrested, their mugshot appears online, and there's some pirates of the internet that farm these arrest websites. And even if you get, it's like whack-a-mole. You get one taken down by writing them a letter, another one will pop up somewhere else, and another one will pop up somewhere else. If you get a sealed or expunged record and you showed proof that it's been sealed or expunged to these websites, the success rate that I've had is extremely high of getting them removed. Once you've been adjudicated or convicted, that success rate drops tremendously. They say we don't have to remove it, but a seal and expungement, a lot of the times their policies and procedures or terms of service, they actually remove it. So that's important as well. And a reckless driving, contrary to a DUI, does allow for a withhold of adjudication. Now, a careless driving is way better. It's a traffic infraction. But in order to get into the careless driving talk with a state attorney, typically you have to have a very strong case. Almost I don't want to say guaranteed, but a very strong motion or factual base of a case. And most time the line prosecutor is not going to have authority to give you that careless driving. They're going to need supervisor approval. There's a lot of jurisdictions that do allow their line prosecutors to have jurisdiction to give reckless driving. I think that's a fantastic trust in a lawyer who's been through law school, been practicing a little bit, and has got their legs under them. That's awesome. Judicial efficiency works great. It builds up a lawyer's confidence. But far too often we see talking to line prosecutors that they don't have authority to really do much of anything on their case without supervisor approval. And so if you can write their mitigation memo for them to close out their file by citing a motion to suppress, by timing out the body-worn camera to the issues that the officer has, by letting them know about their client's mitigation, if they were going through something really tough at that time that really caused them to make a bad decision, and that they've shown that they've done DUI school, they've done the follow-up treatment, they've been rehabilitated, if you will. All those things go a long way trying to humanize your client and talking with the state attorney. And even if you don't qualify for the diversion program itself, maybe getting special permission to enter a pseudo diversion program with some really harsh conditions. Sometimes a client will jump for joy at that opportunity to prove themselves and get this off their record. And the state it suffices the state as well, because they're actually doing more punishment, quote unquote, than they would have if they had just pled out to a DUI. So it's a quid pro quo bargain there as well. But I think the diversion programs are here to stay. At least I hope. I think we're seeing more and more counties in the state of Florida adopt them. Broward got theirs semi recently when compared to Palm Beach and Miami-Dade. And I think it's a great thing for first-time offenders who have made a mistake and they want to earn it. And I mean earn it. I mean earn the reckless driving, earn the ability to seal their record. Um, that's where I really see DUI going. I do see with self-driving cars a lot of case law that is going to really not really, I don't want to say make much sense, but people are going to try to make case law out of self-driving cars. But if you're in actual physical control of that vehicle, you're in actual physical control of that vehicle. So you can't blame Tesla and Elon Musk for operating a vehicle while under the influence. So I've seen lawyers and gone to some conferences where they talk about how it's going to change DUI practice and DUI law. I don't think so. I think the law is what it is in that aspect. And I think just because the car's driving itself doesn't mean you're not in actual physical control of that motor vehicle. So that's another one I know that people like to talk about quite a bit about the new law and changes in AI and stuff like that. Let's see what other questions we have. Experts. So there is a normal faculties expert that you could have. You can hire. You can hire all kinds of experts, even on a misdemeanor DUI, to review the body camera and do an investigation of their own. It's just very rare to see an expert hired in a misdemeanor DUI for various reasons, mostly money and time. And quite frankly, if someone asked the question about, when do you see experts involved or hired in a misdemeanor? Usually normal faculties. We've actually had a rape trauma expert help us beat a DUI because a client had actually just been fleeing someone's house where she alleged that she had been sexually assaulted and molested. And she tells the officer on scene that she had just gone through something traumatic. She can't talk about it. She's breaking down. And the officer just kind of rushes from one thing to the next. And after, unfortunately, digging deeper, the client was telling the truth. And the state attorney even got involved in the other aspect of that. And it was really sad. But there was an expert to evaluate her reaction, whether she was going through trauma of a recent sexual assault. So, you can get really creative with these things. And every case is different. Anyone who says, oh, a DUI is a DUI is a DUI. Oh, man. I'd love to have a conversation with that person because I don't believe that to be true. There's cases where if we watch the body camera, as Adam said, all the way through and just listen to the client and police interaction in the car all the way through and pull the CAD report, CAD report, you can see some internal communications of the officers that they're like, oh, I'm not really sure if she's drunk, but she smelled alcohol. So, I think I had enough. I mean, how are you going to prove beyond a reasonable doubt if you're saying you're not sure and you think, quote unquote, you had enough to even just arrest her? So there's a lot of information that can be collected. I was talking about earlier, information that gets collected that if you don't actually preserve it, it can go away. 911 calls, the CAD report that I was talking about, any surveillance cameras. So, don't just dismiss this as a typical DUI. And again, I was talking about how experts can be expensive. You don't see them typically in the misdemeanor case. But what we do see is our own internal kind of private investigation going on, where we're sending letters of preservation of evidence to the 7-Eleven who can actually get the footage of when our client got in their car and drove away, or where they were doing field sobriety exercises in the parking lot. So you can see a different angle. The receipts of our clients at dinner that night and showing that there was no alcohol on the bill, perhaps. So there's a lot of things that you want to preserve before they can go missing. In addition to that, there's actually a lot, if we're talking about AI, I did an AI CLE, probably find that on our YouTube page if you really are looking through it, where they talked about some different AI and how it's changing the legal industry. And in criminal defense, there is a program that actually captures events that happen on roadways through all the cameras. So sometimes not just red light cameras, there's traffic control cameras that you see that I always thought weren't recording. They're recording, guys. And if there's an event, quote unquote, or incident, quote unquote, that's captured, meaning that there's someone walking outside of a crosswalk, the AI will scale that and capture that event and hold it for a certain amount of time. It's like maybe 7 days, 14 days. I don't recall. If there's a car accident, if there's anything irregular that shows that there's an event or incident that happened, this AI will capture it and house it. You have to pay for it. And then you can get that video and try to beat the case. So, if there's an accident and an officer's lights and sirens are going on, or an ambulance's lights and sirens are going on, that's an event that gets captured on those cameras. So it's interesting to see that you can do your own private investigative work here now with the advent of some AI and tech that you would have to pay a private investigator to potentially do in the past. So that's a long answer to that question. And then I have one final question here. Let's see. What What foundational weaknesses in the administration of field sobriety tests do you typically exploit? How do you prepare to cross-examine the arresting officer on these points? So we may get a little bit of this later with the science that Armand's going to get into, but I can certainly let you know that when it comes to officers administering these tasks, it really goes down to getting the background information that we have. The officers are in a tough spot. Okay, they've got 15 minutes, 20 minutes to make an evaluation of a driver as to whether their normal faculties are impaired or not by doing these circus type exercises that officers themselves know are crazy to do perfectly, but certainly they're trying to do their job. And when they're trying to get from A to Z as fast as possible, whether that Z is an arrest or just completion of the exercises, every officer is a little different. Sometimes you got to take that square peg and jam it into a round hole, and you miss some of the follow-up questions that I'm sure an officer would love to ask if they had time or maybe better training. When a client says, "Yeah, I've had some back," excuse me, when the officer asks, "Do you have any physical ailments that may affect your ability to perform these field sobriety exercises?" "Yeah, just a bad back from work, but other than that, I'm good." And the officer just moves on to the next question instead of saying, "Okay, if you stand on one leg for 30 seconds, are you able to do that? Or your back's, have you taken any Advil today? Do you get medication? Are you in the care of a doctor for that? Are they herniated disc? Are they hurting you today? Have you done any lifting recently that would have aggravated that?" There's a lot of follow-up questions that in a deposition that if we were to take, could take hours. So it's a hard spot for the officers to be in. So I think the common thing that I see missed most is their follow-up questions, because they're just getting the information, writing it down, moving on to the next one. And I think it really puts them in a tough spot to make a determination on someone they just met 5 seconds ago, whether their normal faculties are impaired, and they don't even know how that person normally walks, talks, judge distances, act in size of emergency, operate a motor vehicle, follow simple instructions, et cetera, which is why when you're doing your initial client interview, even when you're at the public defender, when you're doing your arraignment meet and greets, get that information and send a one sheet over to that person, an email, and say, "Hey, I need you to fill out these questions, fill the answers out to these questions." And you can gather some information about that client's medical history, injuries, defense witnesses for that day, what have you, that can really give you the upper hand, believe it or not, in this case, because you're going to have so much more knowledge about your client and their normal faculties than an officer gathered in 15, 20 minutes. And so I typically say, look, the officers administer the test. They do it most times when you have a DUI officer doing them, they do them fairly well, the administration. It's just a matter of how in depth can you really get with someone when you're an officer put in a tough position trying to make a determination whether that person's impaired or not. So that's it. Thank you for your time, and yeah, good luck. If you need anything, you let us know.